Have you ever heard the phrase, never ask a witness a question to which you don't know the answer to? I'm going to share with you why it's something that you should never do, but during the course of pretrial testimony, it's something that I always do. Come join me for a moment as I share with you this great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial lawyer practicing law in the state of New York. So now, if I have a witness that I'm cross-examining at the time of trial, if I ask a question to which I don't know the answer, you want to know what's going to happen? The witness is going to say something that's going to knock my socks off. He's going to say something damaging to us and our position. And you know what? I'm the only one to blame, because I never, ever should have asked that question. Before we ever get to trial, I will have an opportunity to question all of the witnesses that are involved during pretrial testimony, during the course of the litigation. What that means is that I will now have had an opportunity to know what the answers are to many different questions that I've asked. So now, a year or two later, when the case finally comes up for trial, now in front of a jury who's never heard these questions, who's never heard the answers, who doesn't know anything about what went on, now when I ask those questions, I will know exactly what those answers are. You want to know why? It's because I've already asked them during the pretrial testimony process, known as a deposition. During the deposition, I will always ask questions to which I don't know the answer. Doctor, tell me, why did you do this? Why did you do this? What was your thinking for doing this? Tell me and explain. And I will always ask the witness questions about why, who, where, when. This way I now gain that information. It becomes locked in. The witness now locks themselves into having given sworn testimony at that point. And now a year or two down the road when the case comes up for trial, the jury doesn't know any of this that went on. And now I'm going to be asking that witness certain questions. Doctor, isn't it true that you did A, B, and C because you felt this? Yes, it is. And how did I know that? Because I had asked the doctor a year or two earlier that same exact question and got that answer from the doctor during his pretrial testimony. So now, are there instances where I will want to ask a question to which I don't know the answer? Absolutely. Should I do it? No, no, no. You never, ever want to ask a question to which you don't know the answer, because that answer will invariably come back to bite you on the butt. But in the pretrial process, I will always ask questions to which I don't know the answer. So why do I share this great information with you? I share it with you to give you an insight and an understanding into what goes on in the litigation process here in the state of New York. You know, I realize you've got questions or concerns about your own particular matter. Well, if you're contemplating bringing a lawsuit and you've got questions, what I encourage you to do, if your matter happened here in New York, is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's quick video. I'm Gerry Oginski. Have a wonderful day.